FATF – Overview, Adoption, and Enforcement of Sanctions Legislation. A group of 7 countries formed FATF in July 1989 in Paris. The initial purpose of FATF was to develop international standards to combat money laundering. Due to the 9/11 attacks, its initial recommendations were expanded to include combating terrorist financing. The 39-member FATF body sets international standards to ensure national authorities can effectively go after illicit funds linked to drugs trafficking, illicit arms trade, cyber fraud, and other serious crimes. In total, more than 200 countries and jurisdictions have committed to implement the FATF standards as part of a coordinated global response to prevent organized crime, corruption, and terrorism. The FATF leads global action to tackle money laundering, terrorism, and proliferation financing. It researches how money is laundered and terrorism is funded, promotes global standards to mitigate the risks, and assesses whether countries are taking effective action. As a policy-making body, the FATF works to generate the necessary political will to bring about national legislative and regulatory reforms in these areas. FATF's influence is derived from the widespread adoption of its recommendations and its Sanctions and Greylist. FATF identifies jurisdictions with weak measures to combat money laundering and terrorist financing in 2 FATF public documents that are issued 3 times a year. The member states of the United Nations are expected to follow FATF recommendations as per a number of UN security resolutions, including Resolution 2462, issued in March 2019. FATF Recommendation 6 requires countries to implement the targeted financial sanctions regimes to comply with the United Nations Security Council resolutions, or UN SCRs, relating to the prevention and suppression of terrorism and terrorist financings, such as UN SCR 1267 of 1999 and its successor resolutions and UN SCR 1373 of 2001. Efforts to combat terrorist financing are greatly undermined if countries do not freeze the funds or other assets of designated persons and entities quickly and effectively. This updated best practices paper reflects the latest relevant UN SCRs in response to challenges faced by countries in implementing Recommendation 6. Recommendation 6 requires the country to implement the targeted financial sanctions regimes to comply with the United Nations Security Council resolutions relating to preventing and suppressing terrorism and terrorist financing. Recommendation 6 is intended to assist countries in implementing the targeted financial sanctions contained in the UN SCRs related to preventing and suppressing terrorism and terrorist financing. UN SCR 1267 of 1999 and its successor resolutions, UN SCR 1373 of 2001, and any future UN SCRs which impose targeted financial sanctions in the context of terrorist financing. These resolutions require countries to freeze the funds or other assets without delay and to ensure that no funds or other assets are made available to or for the benefit of any person or entity either directly or indirectly. Designated by or under the authority of the United Nations Security Council under Chapter 7 of the Charter of the United Nations, including following the al-Qaeda-Taliban sanctions regimes, or designated by that country or by a supranational jurisdiction according to UN SCR 1373. Such measures may be either judicial or administrative. Efforts to combat terrorism financing are undermined if countries do not freeze the funds or other assets of designated persons and entities quickly and effectively. In determining the limits of or fostering widespread support for an effective counterterrorism financing regime, countries must respect human rights and the rule of law, allow due process, and recognize and protect the rights of bona fide third parties. To assist countries in implementing targeted financial sanctions to prevent and suppress terrorist financing following the relevant UN SCRs, and in a manner consistent with fundamental principles, through a robust and transparent targeted financial sanctions regime, FATF relevant recommendations are available. Effective freezing regimes are critical to combating the financing of terrorism and, as a prevention tool, accomplish much more than freezing terrorist-related funds or other assets present at any particular time. For designations under sanctions regimes, the FATF's Recommendation 6 requires countries to have authority and effective procedures to identify and initiate proposals for designations of entities and persons targeted by the sanction regimes, consistent with the obligations set out in the relevant UN SCRs. FATF refers to the countries on this list as high-risk jurisdictions subject to a call for action. The sanctions list contains a list of countries that FATF has determined as countries or jurisdictions with serious strategic deficiencies to counter money laundering, terrorist financing, and financing of proliferation. This list currently includes countries such as Iran and North Korea. Member countries of FATF are expected to apply countermeasures against countries subject to sanctions to guard the international financial system against the risks arising out of those jurisdictions. FATF refers to the countries on this list as jurisdictions under increased monitoring. The Gray List is a list of countries that do not merit inclusion on the sanctions list but have strategic deficiencies in their anti-money laundering and counterterrorism financing regimes. These countries have not made sufficient progress or otherwise committed to action plans to address the deficiencies identified by FATF. Ongoing failure to address deficiencies could eventually result in being moved from the Gray List to the Sanctions List. Members of FATF are expected to use caution and consider the risks of those countries on the Gray List.